number 20, the people of the state of New York versus Jose Perez. Thank you. Good afternoon, counsel.
Good afternoon, Your Honors. Harold Ferguson for Appellant Jose Perez. We would request 2 minutes for rebuttal in this case.
Sure.
And we're certainly hoping for a better result than the decision that came this morning where I lost 7-0 last month.
Springs eternal.
Absolutely. That was my thought exactly when I read it this morning. I can't do worse.
So, counsel, is it your position that we use the North Essential Elements analysis?
No, Your Honor. What it is that this is not a misdemeanor sex crime. That what you had here is that the appellate division out of whole cloth reached a decision on an argument that was not raised nor was decided on by the SORA court in this case.
So if that's the case, right, then they're maybe exercising their interest of justice jurisdiction, then what are we doing here?
Your Honor, these are unpreserved issues. The people did not argue this. The people did not argue that this was endangering the welfare of a child.
I think the judge's point is the appellate division can reach arguments like that. We can't. So if they base their decision on an argument that we can't reach, our general reviewability is nothing. So we would have to affirm or dismiss because they've reached it on an issue that we can't review.
I believe we can reach it because the appellate division, this was an issue that was not raised by the people below.
Right.
This was not raised on appeal by the people.
But we just had a dismissal of a case like this, I think, where it was a criminal case, I believe, but where they reach an issue in their interest of justice power, in this case, a sufficiency, I think it was, and we can't reach it. So there's no way for us to review that decision because we can't consider that at all.
But, Your Honor, they did not say that they reached this in the interest of justice. They said it was as a matter of law.
What
Yeah,
they say
but what they say is not controlling.
I understand that
we
what
look
they say is
behind
not
that all the
controlling.
time.
But you had here a situation where this is a crime against public sensibilities. This was an outlier decision by the appellate division. Every single case involving a misdemeanor sex crime that's recorded in the appellate courts of this state all have held that the misdemeanor sex crime is one that's contained in Article 130 of the Penal Law. And every other appellate court case dealing with the issue of lewdness has specifically held that it's not a misdemeanor sex crime.
As you know, the appellate division often reaches issues and does things in the interest of justice we perhaps might not agree with, but that isn't a basis for us to get around our jurisdictional role.
I understand where Your Honors are coming from, but we're asking this court to take a look at in essence, what they are doing is affirming the decision of the SORA court. And what we are arguing is that there is no basis for them to affirm the decision of the SORA court. And therefore, I do believe that this is still within the confines of the jurisdiction of this court. While they call it a misdemeanor sex crime, what they are actually doing is affirming the decision of the SORA court. And therefore, that's what's before this court. Did they make a correct determination that he should be assessed 30 points under risk factor 9? And it's our position that they do not, that there is no basis to assign 30 points under risk factor 9 because it doesn't fall within the confines of the statute. It doesn't come under either Correction Law 168, and it's certainly not one of the sex offenses denoted in Article 130. This would create a terrible precedent where
So if you're right, did the people get a chance then to go back and argue whether there should be an upward departure?
On a practical basis, it would be extremely difficult for that to happen.
And that's because your client's already deported.
Our client is deported
and not
in
here,
2012.
subject to the mandates of the court. And maybe we should have granted the motion to dismiss, but that ship sailed.
And again, that's not something that the people have requested before this court. They did not request that this be remanded for an upward departure hearing. All they simply are asking for was an affirmance of the appellate
What if we
division's
agree with you and we reverse? What happens?
He would be reduced from a level 2 offender to a level 1 offender.
And they would have no opportunity then to argue that.
Because he's been deported.
Well, there have been cases, and we've had these in the appellate division, where the idea is that through video conferencing, it is possible to conduct a SORA hearing by video conference. So there is the possibility that it could still be done by video conference upon locating Mr. Perez in the Dominican Republic. So it's not that they wouldn't have an opportunity. It would just be somewhat difficult to do so. But there are cases that have allowed for video conferencing for such a situation, because certainly, obviously, he's not coming back to the United States. The United States is not bringing him back for a SORA hearing after he was deported in 2012. So, yes, Your Honors, if you remanded it to give them the opportunity for an upward departure hearing, there is a mechanism to do that.
In terms of just clarifying the law, so I can understand what you are advocating is the way to interpret, excuse me, the requirements of SORA. Your position is not that the public lewdness conviction doesn't count at all.
No.
Right? He's going to get some points under criminal history. It's just not the 30 points,
Right,
I understood your argument.
He gets 5 points instead of 30 points, and that lowers the score to 60, which would be presumptively level 1.
But that allows the people, as I think you are conceding at that point, or even the board.
Right.
I assume you would concede that the board could have recommended an upward departure.
That's correct, Your Honor. And in fact, that is
People
what...
could have sought an upward departure, whether the board made that recommendation or not.
Right. And in fact, the other appellate division cases that deal with the issues of public lewdness do reference that and say this is something that was not taken care of as a sex offense under the corrections law or the penal law, but it could still be considered in essence by an upward
But why
departure.
aren't they correct? She'll correct me when she gets up if I've gotten this wrong. As I understood their argument below was that they were relying on the conduct itself, the sexual nature of the conduct. Why isn't that enough to get this to be a point allocation issue versus an upward departure issue?
Because as defined under the correction law, it is adjudications and convictions. There is nothing in the correction law 168 that allows for the assignment of 30 points based on solely the conduct involved. It specifically references convictions and adjudications. The argument they're making about conduct does not exist in the correction law, and they cannot get the points on the basis of conduct. It is simply the wrong argument. At one point, they were making an endangering the welfare of a child argument, but that was specifically retracted by the people. So they don't argue that.
And they don't bring that back when it comes back for day 2 of the hearing.
No, it's
When
no.
they argued on day 2 of the hearing that they were going based on conduct, as I read the record, they said, well, you know, we'll withdraw that argument for now till we get the documents about the underlying conduct, right? Then they get the documents and then they say, yeah, we're going on the conduct. Could that be considered preservation of that issue?
Absolutely not, Your Honor. It would be no different than if we make some generalized argument asking for dismissal without articulating it. Here, the people specifically say at the original SORA hearing that they were retracting the argument related to endangering the welfare of a child. That required them at the second day of the hearing, after they got the information, to renew that argument. They did not renew the argument. Only argument they're making at the second day of the SORA hearing was that it was based on conduct, not on the basis of anything else. So we ask this court.
So you've referenced the convictions and adjudications. I just want to be clear. You don't dispute that there is, and you concede that there is a conviction in New Jersey for this, what New Jersey calls a felony level public lewdness.
That's correct, Your Honor.
Okay.
But
None of your and you have never argued that you have to actually have that certificate of conviction in evidence before the SORA court.
No, Your Honor, we're not disputing that he has the New Jersey conviction. Although on the facts of it, one of the interesting things, if you look at the statements of the victim in that case, my client doesn't have 3 arms. She indicates that with one hand, he's grabbing his genitalia. With the other hand, he's giving her and her brother the finger. And with his other hand, he's blowing her kisses. My client doesn't have 3 hands.
What is the New Jersey statute under which he's convicted?
He's convicted under the public lewdness statute
The
in New Jersey.
citation for it. Do you know the statute number?
The statute number is in our brief. I will get it for Your Honor for
Brief, that's fine.
the rebuttal part of the argument. And we ask this court to reverse the decision of the appellate division.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court, Jean Joyce for the Brooklyn District Attorney's Office. Your Honors,
So was the endangering argument preserved?
I would like to broaden the scope of the discussion to the fact that under Factor 9, there are 3 ways for this Court to conclude that 30 points were properly assessed.
Okay, well, we can get to that, but is endangering one of them in this case?
Yes, it is one of them.
So how was it preserved?
So, first of all, people are the prevailing party in this case. 470.052 does not apply. We were not required to set forth any error of law on the record, nor when this court is faced with a pure question of law as respondent, were we required to preserve any particular issue that the defendant could not have countermanded factually. In other words, there are no facts at the hearing court level that are up in the air, in dispute.
So it doesn't matter what you argue to satisfy your burden of clear and convincing evidence to establish 30 points under Factor 9, you can bring it up at any time, even in this court for the first time? Can you do that?
Under Sega v. State, this court is permitted to consider a pure question of law. I think you're addressing the narrower point of what was the meaning of the words spoken by the ADA when she said, I will retract the factual recitation that I made with respect to the Florida conviction. She made a misstatement of fact. She had a piece of paper, she was relying on it, it happened to be the Florida underlying facts. She said, I would like the time to go and get the New Jersey facts. When she did, the court said, okay, let's go. What are these underlying facts? She, at that point, was not required to say, I now retract my statement that I retracted those facts.
But doesn't the defendant have the right to be aware that that's something that he needs to be arguing?
And certainly, she argued every permissible permutation of what they are arguing on appeal. But I would like to get to the merits for a moment and say, Factor 9, as set forth by the board, does not require any Article 130 statute to be considered. It could be a sex crime, a sex offense that is not a registrable offense, not an Article 130 offense. It may be.
So if you can show any conduct underlying any crime to be of a sexual nature, would that then, well, I assume it would apply not only to foreign offenses, it would apply to New York offenses, right?
I'm not talking about conduct. I'm talking about a conviction. The Factor 9 requires.
But you said in the SORA court that you were not relying on the crime of conviction. You were relying on the underlying conduct.
Your Honor, I think that is a very narrow and circumscribed interpretation of what the ADA was saying. She was responding to the defense argument that the New Jersey lewdness conviction is not the equivalent of the New York lewdness statute.
So you are not asking us to make a rule that the underlying conduct is sufficient to bring it within the 30 points of the Factor 9?
No, Your Honor, I'm not asking for conduct alone. I'm asking the court to exercise its power to decide a pure question of law, and that is whether under Factor 9, an out-of-state conviction for fourth-degree lewdness, which is a sex offense and has an element of sexual gratification, conduct toward a child under the age of 12, and exposure of one's genitals, whether that offense may be given 30 points as either an adjudication of a sex
So
offense.
it does require looking at the conduct, though. The
It
whole argument turns on the conduct, because that was the point of the adjournment, right?
It was actually defense counsel at the hearing who wanted to know what is this underlying conduct of this lewdness conviction, because defense.
No, but I'm asking about the people's position.
Right, our position is that you look at the elements of the offense for which the defendant was convicted, and this offense has a sexual element,
So
an element of a sex offense.
In the record for this case, I'm having a great deal of difficulty finding a document that shows what the crime of conviction was, what the statute number was. Can you point me to it?
The statute under which he was convicted was fourth-degree lewdness.
To a place on the record where I can find that. In the record before the SORA court.
I believe they were relying on the criminal history report where and there is a lewdness, which is a lower count of the charge, which was set forth in the complaint and warrant, which was actually called a tender years sexual assault.
The complaint and warrant I see, and that's a
Right.
different statute number that he's not convicted under, I believe.
Right. So I think you have to look at how they described it in the record in terms of what the court said. The prosecutor referred to, I have the adjudication, and, I don't have that. She referred to it, but it's not in the record.
So is your argument that if a foreign jurisdiction identifies in some way as an element that the crime is sexual, even if in New York it is not viewed as a sex crime, that then fits within the point allocation, put aside right now the departure, the point allocation of criminal history?
Yes, Your Honor. That's my argument, that,
What's the support for that?
well, if you look at, there's a couple ways to get there. First of all, in the guideline itself, the only place in the guideline where it states that a penal law offense must be considered is in the commentary, that's page 14 of the commentary for Factor 9, where the board said if you have a violent felony, that means penal law 70.02. So clearly the board, if they had wanted to say misdemeanor sex crimes come under Article 130, sex offenses come under Article 130, or registrable offenses, they knew how to do that. Moreover, in this court's decision in People v. Izzo, you looked at Factor 3. And similarly, the argument was, well, Factor 3 has to be, there has to be a registrable offense. And the court said, no, absolutely not. The language was much broader. It referred to sexual conduct. Therefore, we're not going to limit the board.
But did it refer to conduct here?
No. I'm not relying on the word conduct. I'm saying the board set forth generic categories of crimes, misdemeanor sex crimes, sex offenses, which is very broad.
But in your own brief, you've attached the guidelines, and for Factor 9, it only refers to convictions or adjudications, and in fact, convictions or adjudications is actually underlined in this section. Where does it say that conduct is all we need to look at?
No, it does not say that.
Okay.
I'm saying that in Factor 3, in the Izzo case, this court rejected the notion that the guideline required an offense under 162A. The board didn't say that, this court held. The board was much, much broader by merely referring to conduct. I'm not importing that
But
into Factor 9.
Factor 3 is about number of victims.
Right, and I'm not-
But whereas, Factor 9 is about a criminal history and speaks specifically to something one could look up on a criminal history
Right.
of that particular individual who's coming up for classification.
That's correct, and you...
So, but let me ask you this. What from the people's perspective, is the danger in pursuing the proper classification in the way counsel is advocating for us to read the statute, which is convictions are adjudications, you do your point scale. He concedes that his client's got to get some points because indeed he's convicted for this crime in New Jersey. But anything else about the conduct and the sexual nature of it that perhaps doesn't fit it easily within any of these numerical categories under Factor 9, you have the opportunity, both the board and the people, to argue for an upward departure and present all of that conduct, make the argument. It's the same standard, right? The clear and convincing evidence standard. Why is the people, what would make this difficult for the people to pursue that? If we were persuaded by this way of advocating the interpretation of the statute.
It's not a matter of what's easier, whether we did an upward departure or not. It's that how are you going to recognize out-of-state convictions that have a sexual element in them that is, you know, New Jersey, a sister state, says, look, this fourth-degree lewdness, against a child is a sex offense. It is labeled a sex offense. It comes within the definition of sex offenses.
I thought his point is that in New York, it's not a sex offense.
But that doesn't matter.
And so that allows the people and/or the board to argue for the upward departure because the point scale will not fully represent the nature of the risk because it won't capture this aspect of the conviction.
Right, but that's not as
I think
guaranteed.
The concern is that you basically want two ways to do this. You want a flexible accounting of points, and then you also want to be able to use the upward departure method. And I don't know that that's really how the guidelines are written.
So the guidelines are written with really one main purpose, and that is to assess the risk of reoffense and to be aware and assess the potential harm to victims. And if you just look at this particular set of facts, this defendant committed this lewdness crime in New Jersey and then went on and committed the higher offense in Florida of an actual groping and sexual touching of a 10-year-old child. So he should have got those points, I think, in order to properly weigh his
But that's what the guidelines clearly say. That's the problem with the point scale. It may not capture exactly what you're referring to, the nuances about someone's particular risk, because, of course, it's the SORA-eligible crime that you start with. So in that sense, the board has already taken into consideration the point that you are making and responded to it.
Well, not entirely, because going forward, we have to look at what's his, if he had stayed in New York, what would his future potential risk of harm be, and his risk of offending, of reoffending, I think it would be very, very high.
If the endangering argument was properly made and preserved, that would provide another way to get the points rather than to have to go based on the upward departure, right?
I mean,
possibly.
If you felt that an equivalent elements test, sort of the North v. Board test, was appropriate, yes, this would have been endangering in New York. But I don't think the board should be limited to New York crimes.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
A couple of points. Your Honor, it's NJSA 2C7-2. It is the New Jersey public lewdness crime. The people make the argument that they've actually...
And just to be clear, you don't dispute that everybody is operating on a concession that he was convicted.
Oh, he was convicted. There's no question. There's no question. But as to the point that the people were making about that that the people's argument where they retracted it was in reference to the Florida case, that's not true. A22 is when they're referring to, of our appendix, is when they're referring to the Florida matter. It is A26 when counsel is arguing that there was no allegation of endangering the welfare of a child in New Jersey, and that is when the people say, we retract all of those statements. So they have specifically retracted in the SORA court the argument that this was endangering the welfare of a child. And they shouldn't get a second bite of the apple as to that, because they had the opportunity to do it at the renewed SORA hearing, and they didn't do it. Their argument is not preserved. The people can't turn around and say that this is just a question of law and that we don't have to make the arguments. It's applied to us as criminal defendants uniformly that we have to make the arguments. Here, they didn't make the argument. All they argued was that it was conduct, and as Judge Rivera just pointed out, that's not what's contained in the correction law. What's contained is adjudications and convictions. And
Just to be clear, does New Jersey classify public lewdness as a sex crime?
it is a non-registrable offense, as it is in New Jersey, just as public lewdness is a non-registrable offense in New York. And this court in McNamara understood that it is a different classification of public lewdness than other types of crimes.
But
And
is
when-
there a sexual element to the crime? Under New Jersey law?
Under New Jersey law, yes, there is. But again, and when you look at the appellate division's decisions in LaPorte, in Davis, and Brown, they all looked at public lewdness, and each of those courts conceded that this was a crime that had a sexual component, but that it was not a misdemeanor sex crime. For 30 points to count, it has to be a misdemeanor sex crime. And it's not just a semantic thing. It has to be a misdemeanor sex crime, not a crime that has a sexual component. With the exception of this outlier decision by the Second Department here, every recorded appellate division case on this issue has come to the conclusion that public lewdness in New York is not a misdemeanor sex crime. Therefore, he should not have been assigned 30 points for this. And that as a result, once you took that away, he should be adjudicated a level 1 offender. Thank you, Your Honor.
counsel.